Good evening, everyone, and thanks for joining us for Crime Unveiled with Courtney Bennett on this Tuesday evening. I'm bringing on right now Professor Jeffrey Swartz. Professor, you have served time as a law professor, also as an attorney. You have an extensive legal background. And tonight we're going to talk about the Jennifer Crumbley case because motions have been filed by her appellate attorney recently. I just want to thank you for joining me and also offering all the insight that you're going to tonight.
Well, it's my pleasure. I don't consider it serving time when I did those things, but yeah, okay. You're going to talk crime, okay?
That is true. Okay. You spent a lot of time as an attorney and also a law professor.
That's much better. Thank you.
Yeah, there you go.
Okay.
Yeah. Talk to me a little bit. You've gone through the articles, recent articles when it comes to the Jennifer Crumbley case. Mm-hmm. Her appellate attorney is now asking for her to be released from prison. We know that she was sentenced last year, now asking for this release. You know this case. We've talked about this case. Talk to me a little bit about where does this stand? Could she be released from prison?
You know, the problem is that the Crumbleys from the very beginning were caught in what I consider to be a very political situation. Forgetting the crime that was committed by their son. And I doubt seriously until she gets to a higher court than the Court of Appeals that they're going to let her out of prison since she's facing a 10 to 15 year sentence. Remember, she's getting credit for time served, so she already had 2 to 3 years in to begin with. I think that if you look at the standards for getting a bond, there's no question she is not a danger to the community. She did nothing except for, if you want to call it that, being a bad parent. And that doesn't make you a danger to the community. And she certainly can't go anywhere. She hasn't got any money to go anywhere. She, and her husband have absolutely lost everything as a result of what was done to them starting at the beginning of this prosecution. So I don't see any reason not to release her. The problem is she can't post a bond. They would have to release her on an ankle bracelet, GPS locator, that type of thing. She could get out. I think it's appropriate for her to get out. She's already served more than the time she would have to serve under the minimum sentence allowable under the statute and based upon the guidelines. So it would be the right thing to do. If they let her out, it means that they're going to reverse her conviction, that they're convinced that there is a strong likelihood that her conviction will be released and that she should be released from prison. And that could happen. And if I were her or her lawyer and she got out, I would be thinking that way.
So she had a different attorney, obviously, during this whole process, getting this new appellate attorney that she, from what we can see, she retained back in December. He files all of these motions. The latest motion came yesterday. He filed it in Oakland County Circuit Court with Judge Cheryl Matthews. And in it, it says that he believes that there was a smear campaign done by the Oakland County Prosecutor's Office by hiring these public relation firms to release information about the Crumbleys during the trial. So where does it stand with that? What does that look like? Is that against the law?
It may not be against the law, quote, quote, close quote, as a violation, a criminal violation of any kind. However, it could be deemed to be a real substantial interference with their due process rights. It is an attempt by the prosecutor's office to prejudice the jury pool. Remember, we heard all about this when Donald Trump would go out there and say all these things about the prosecutors and the witnesses, and the judge was an attempt to poison the jury pool. That may be exactly what Ms. McDonald was doing through these PR firms, to poison the jury pool, to create anger within the community, that anger that she carried into the trial, and that the way she structured her presentation was specifically intended to anger the jury and keep them angry. That was her way of presenting the case. Her closing argument was feeding into that anger. So I can understand why one would think that the PR firm was hired on the government money, okay, to pursue prejudicing the jury. It's a legitimate and very strong argument.
And something that's interesting, the prosecutor's office releases a statement after this motion was filed and says that they were just doing and handling the PR side of it by hiring this PR firm because they were getting overwhelmed with media requests. And that was part of their statement yesterday.
That's something that a public information officer that worked for their office or a public information officer that could be furnished to them by the county could handle. They're used to media requests. They don't need a PR firm to handle a no comment or to give an interview if they choose to do so, or to answer questions at a press conference. They don't need that. So if the PR firm was hired for that purpose, it was a waste of Oakland County money.
Are we going to see more motions filed by this appellate attorney, Michael Desi?
I think that he's going to concentrate right now on trying to get her out of jail. He's going to concentrate on the issues in the appeal, and they are substantial. And as a result of which, he has a reasonable likelihood that he is going to succeed on appeal. Maybe not with this Court of Appeals. Again, the politics gets involved, but certainly in front of the Michigan Supreme Court when it gets there.
Is it typical to have another attorney that you retain after you've been in prison to help you through this appellate process?
Well, not maybe. Let's just say after a conviction. It's not unusual that trial lawyers do what they do. They are not appellate lawyers. Appellate lawyers know best the ins and outs of the appellate rules, how to really write briefs, how to highlight and pick the 2 or 3 best errors that they can pursue, and to make oral argument and to use what the trial lawyer has done in preserving any error that is there. I did appellate work for about 7 or 8 years after I left the bench, and I will tell you that it is very specialized. It is very different. It is something that you don't get a trial and you don't get a chance to argue new evidence unless you have it. In this case, they do have it, but mostly you're arguing the errors that the judge committed during the course of the trial, the things that prejudiced your client that should not have occurred and happened to cause a conviction where maybe there shouldn't have been one.
Is this more challenging, would you say, filing these types of briefs opposed to going through the trial process?
You know, they're 2 completely different things, and they're both very challenging. Having done both of them, I can tell you that they're very different. And so therefore, you know, you just sort of have to look at what the trial lawyer does. The trial lawyer's job is to represent the client at trial. And their job is to make sure that the defendant's constitutional rights are protected and where they're not, to establish error in the admission of evidence or other legal matters. It is then up to the appellate lawyer to read the record, make sure that the record is substantial enough, because the appellate courts don't take evidence. You operate on the transcript, on the record that exists. You can't create a new one for the most part. And so therefore you have to work with what you have. And that's kind of different. You're trying to move things around, trying to convince the court that there was error that was done by the judge, either in instructions or ruling on evidence, trying to prove or establish that it wasn't harmless error. Those are the kind of things that an appellate lawyer does. It's very specialized, as is trial work. And having done both, I found both challenging, to be honest with you.
Her trial was now almost a year ago.
Yes.
And is it odd or out of the ordinary that it's taken this long to have this appeal, to want to be released from prison?
It's not unusual. And a case is complicated. First of all, putting the record together could take the clerk an extended period of time. And they have to transmit that record to the appellate court clerk. Once that record has been established, then it's time to write briefs, file motions in regards to the record, establish things. In this particular case, apparently, after the record was certified, the newspaper seems to indicate, the articles that I read, that there was some evidence that was not given to the defense attorneys that under a case called Brady versus Maryland, they must give. And Brady versus Maryland says anything the prosecution has that could be exculpatory or could be used to impeach the testimony of a witness must be furnished to the defense. And if it is true that the two administrators at the school gave testimony to the grand jury and gave testimony at the trial with an understanding, maybe not in writing like it usually is, that if they cooperated fully and told the truth, they would not be prosecuted, that promise is an incentive for them to testify a certain way. And because of that, that should have been the subject of cross-examination. If that really did occur, for all intents and purposes, this appeal should be a slam dunk. It should be so immediate that the court should have no problem ruling on anything else that happened and just say under Brady versus Maryland, the government failed, the state of Michigan failed to comply with what they are required to do under the rules of criminal procedure and federal constitutional law, and therefore she's entitled to a new trial.
Is it surprising at all that James Crumbley has not filed any motions, or an attorney on his behalf have not filed any motions similar to Jennifer Crumbley?
Well, I'm not sure that I'm surprised he didn't file a motion for a bond. However, when it comes to this testimony, this Brady material, if it was withheld, he's entitled to a new trial too, because that is testimony that would be used to impeach the witness, the testimony of the administrators. You're testifying here because you were promised immunity, and the government says there's no such agreement. That's not what I asked the witness. I asked the witness, were you promised you would not be prosecuted? Did you testify for them because you were made this promise? And that's all you need to ask. And at that point, what their understanding is what's important, not what's in writing.
Are we still looking at a long process here?
Yes. It's a simple answer. We are. We're still looking at briefing. We're still looking at oral argument. We are still looking at the decision to be made by the Court of Appeals. And if there is no success there, it will end up in front of the Michigan Supreme Court on a lot of issues, including whether there really was a criminal offense committed here. And we can get into that if you want to, but I've been saying there wasn't since they got arrested, 3 years ago?
Yeah.
I from the word go, I said that their due process rights were being violated and that Ms. McDonald was on a political witch hunt to make a name for herself for whatever political office she intends to seek 2 years from now. And there are a couple of them I can think of. So as far as I can see, it's going to take some time. I just don't know how the Court of Appeals is going to get around this Brady issue. I really don't know. So
let's say that they rule on her case. It will also apply, like you said, to James Crumbley's case as well, regardless if he has retained a appellate attorney. It will still apply because they were essentially the same case, tried separately.
Even if his appeal had been completed, he would have the right to file a motion for post-conviction relief, claiming new evidence, claiming constitutional violations. And Judge Matthews, I want to hear her say that. I really would want to hear her say, and she's not going to say it, I would really like her to say, yes, this was a Brady violation. This was purposeful. This was a constitutional issue. It was prosecutorial misconduct. Have a nice day, Mr. Crumbley. You are free to go. And I think that really could happen. If they withheld this kind of material, that's prosecutorial misconduct. And that calls for a dismissal with prejudice. It could get really bad for Ms. McDonald if this happens.
When it comes to this case received national attention, probably across the world as well.
I can vouch for that.
Yeah, okay. You did a lot of interviews nationally talking about this case.
Yeah, I can vouch for that. Yeah, go ahead.
So Do you think that this is going the way that it is right now because the case sets a precedent? They became the first parents
Mhm.
who were charged and then convicted
Right.
in connection to a school shooting. We've never seen that before.
Right.
So is that why this case is so important right now?
It's important because, for example, you have a case up in Wisconsin that's going on right now where the gun belonged to the parents, and the young lady goes to school and shoots a couple classmates and shoots a teacher, and the gun belonged to the parents. And the Wisconsin authorities are considering the same kind of charge that Miss McDonald did. I said at the time that she put out these charges, I said the same thing when the Crumbleys were convicted, and even pending the conviction. I said this sets a terrible precedent that now if you are a bad parent, okay, or you don't notice that your kid is troubled, or you don't hide your gun well enough, even though you don't have a legal duty to do so, you do now in Michigan, you didn't at the time, okay, that you can be held responsible for what your child does. And I opined it's not just guns, it could be a baseball bat, it could be anything that could be used as a weapon that's in your house that your kid goes out and beats somebody to a pulp with. It's just not a good precedent. Now, if you set a statute that says you must secure the weapons and this is how you have to secure them, that's a different story because now you have a legal duty. Before, there was no such legal duty. This precedent is now being carried out in other jurisdictions, and unless or until some court says it doesn't work that way, it's going to continue.
And it's so interesting because as a most recent case, we saw the Supreme Court say that the Michigan Supreme Court say that one-man grand juries can't be used in the state of Michigan, which then overturned all of these cases. And all those cases had to go back to the courts because they used them in so many counties, Wayne County,
Right.
Genesee County, and it ended up costing more money.
In fact, in the state, I got to point this out. What they were doing in Michigan is actually the way it's done as a matter of course in the state of Florida. We authorize prosecutors to hold what we call pretrial conferences and take sworn testimony from witnesses. And they do, and then they fill out with the form, which creates what we call an information. And the information looks just like an indictment, only it is signed by a prosecutor that swears that he took sworn testimony and probable cause exists and all those kind of things. In essence, it's a one-person grand jury. But if that is not part of what can happen under your rules of criminal procedure, and all they did was try to get around the idea of having a full grand jury hear these cases like they do in Ohio, for example, by naming a specific prosecutor as a one-person grand jury, that's trying to get around the idea that the purpose of a grand jury is to have members of the community hear testimony and determine whether there's probable cause for charges to be filed. And if prosecutors tried to get around the grand jury process by doing that, I don't blame for the Michigan Supreme Court from overturning these convictions. And now all of these thousands of convictions that may have existed are now questionable.
Yeah.
It's a substantive issue. It's not a procedural issue.
As we wrap things up here, Professor Swartz, is there anything else that you want to talk about or add that we didn't?
You know, I think we talked about everything. I will say that on a personal basis, I believe that this appellate lawyer is got it all on the ball. He is ahead of the curve. He knows exactly where the issues are. There were substantial error in the trial itself, but what they have found now may call for reversal and dismissal for prosecutorial misconduct. And I wouldn't want to be Miss McDonald coming into court trying to justify the failure to disclose this kind of evidence. She's created a real mess, is what she's done.
Well, I just want to thank you for your time this evening and sharing all of that insights. It's always a pleasure to talk with you.
My pleasure. Take care of yourself, Courtney. Have a great day.
Thank you. Bye. Have a good night.
Good night.
Well, thank you for joining us for Crime Unveiled with Courtney Bennett. We hope that you'll join us next week, Tuesday nights at 7 o'clock for another all new episode.